Okay, so we did chapter 8 dealing with impasses, strikes, and dispute resolutions. And I'm Cameron Cashdaller.
I'm Abraham Mao.
I'm Janie Ray.
I'm Brandon Stopar.
And I'm Bailey Wilson.
All right, so strikes and lockouts, types of strikes. First one is going to be an economic strike. It's for better wages, more and better benefits, work rules, and it's the most frequent one. And a lockout is actually initiated by the employer. It's when they're trying to do the same thing as the economic strike, but like instead the employer tells them to not come to work and like don't come back until it's like the dispute is over. And then the next one is an unfair labor practice strike. And it's when pretty much the employees feel like they're being treated unfairly, kind of like exactly what the name says. And then another one is a recognition strike. And that's pretty much when the employees or the union like force an employer to recognize them and like work with them on different issues. The sympathy strike is just other employees just kind of joining on a strike just to help out with like their other like fellow coworkers. And the types of strikes continued are wildcat strikes, which are just strikes over grievances, not during the contract negotiations. A jurisdictional strike is strikes over the assignment of work, like to the bargaining unit employees. Non-economic strikes are strikes over permissive bargaining items during contract negotiations. And the final one is going to be general or political strikes. It's just mass protests against like government policies, and it's mostly common in Europe and different countries. And the legal treatment of strikes, economic strikes, unfair labor practice strikes, and recognition strikes are all protected by the NLRA, which is the National Labor Relations Act, where workers cannot be disciplined or fired. Workers can be replaced. So like, since they're not working, the employer can go get different people and continue producing stuff. And then for the recognition strikes, the employees are only permitted to picket for 30 days. And for unfair labor strikes, the NLRB must find out that there was an actual unfair labor act committed. And then sympathy strikes and wildcat strikes may be protected by the NLRA. They're not always protected. In that case, that's if there's a no strike clause in the contract that includes sympathy strikes and wildcat strikes. In this case, workers can be disciplined or discharged. And then they can be protected if they're not mentioned in that no strike clause. But again, they can still be replaced. And general/political strikes, non-economic strikes, and jurisdictional strikes, and they're not protected by the NLRA. And strikes have been declining since the 1950s. The U.S. strike activity is at an all-time low right now. In the 1950s, it exceeded 400 strikes per year, which was in the early 1950s. 1970s, it ranged from 250 to 425 in the early 1970s. And then from the 2000s to 2010s, it plummeted to less than 20 strikes a year. And strike rates have declined from 15% in the 1970s to 5% in the 2000s.
Okay, so the next section talks about strike replacements. The first part of this section talks about the McKay Doctrine. So first, we need to understand how this occurred. So back in 1935, telegraph operators at McKay Radio and Telegraph Company went on a strike in San Francisco. The McKay Radio and Telegraph Company then hired 5 replacement workers because of these workers going on strike. And because of this, the 5 strikers were not allowed to return to work because their positions were already taken by 5 others that were hired. And because of this, this resulted in a Supreme Court case, the NLRB versus McKay Radio and Telegraph Company. And the Supreme Court found that McKay Radio was discriminating the 5 workers. So the McKay Doctrine is basically a rule that employers cannot discharge legally protected workers and that employers also cannot hire replacement workers for them. The next section talks about replacement workers in unfair labor practice strikes. So this whole section talked about a specific question: can employers use permanent strike replacements during unfair labor practice strikes? So other courts decided that employers cannot use permanent replacement workers during unfair labor practice strikes. So that kind of answers the question. The NLRB decides if workers are engaged in unfair labor practice strikes. And this is stated in the textbook. If an unfair labor practice has anything to do with causing a strike, or if it appears that the employer's unlawful conduct played a part in the employee's decision to strike, then a strike is an unfair labor practice strike. The next section talks about efforts to ban permanent strike replacements. The McKay Doctrine wasn't controversial in its time, but it sparked a debate when President Ronald Reagan fired ATC workers during the illegal PATCO strike. Permanent replacement workers were used in multiple strikes. This included 5 or 6 of the different strikes that they were high-profile strikes, and because of the results of these, the banning the use of permanent strikes replacements was the labor movement's top priority between 1985 and 1995. And then workers are fired for going on strike.
So in section 3, chapter 8 talks about other pressure tactics. In the 1980s, other pressure tactics such as boycotting, work slowdowns, corporate campaigns were used instead of striking. Employees have used these tactics to pressure their employers in a negotiation for a better work environment. An increase in strike replacement has occurred due to employees turning to these different tactics so that their jobs are not lost. And in the public sector, these pressure tactics have occurred more frequently when strikes are prohibited. Boycotting is a strive to encourage a certain company's customers to stop doing business with them. So the difference between boycotting and striking is a boycott is done from outside of the company, where people who come together refuse to deal with certain subject of action. And a strike is done inside of the company and is when employees refuse to work until change is made in their work environment. So any hostile environment, stuff like that. Work slowdowns are when employees reduce their productivity and efficiency to the company. Employees follow their employees' rules and that's it. They do no extra effort. So it's just like doing the bare minimum. And corporate campaigns are they're a way to give negative publicity to a company or industry. It's the most aggressive tactic used by the labor movement, linking them to politicians, agencies, and activist organizations.
The next section of our chapter talked about third-party dispute resolutions. Third-party dispute resolutions use neutral third parties to settle bargaining impasses, trying to avoid costly strikes. In private sector, third-party dispute resolutions are usually voluntarily, as they are rarely enforced on labor and management, In the public sector, although serving the public interest means that third-party dispute resolutions are often used. Some of the mechanisms for third-party dispute resolutions. One is mediation. That's when a neutral third-party mediator tries to facilitate an agreement but does not have the power to do so. Another mechanism is arbitration. That is when a neutral third party is a fact finder who investigates the dispute and makes recommendations for the settlement. And fact finding lacks control over the process and the outcome. Next section talks about mediation. Mediation is a dispute process in which neutral third parties, the mediator helps negotiators avoid or resolve an impasse by reaching an agreement. The use of mediation does not need to wait until an impasse occurs. Orchestrators, they focus on trying to facilitate productive negotiations, while deal makers see negotiations as over when they enter, therefore not as concerned about renewing the negotiations. Under the NLRA, mediations are voluntary.
So moving along with that, there is interest arbitration. Interest arbitration is a way of resolving the disputes by a neutral third-party arbitrator or arbitration panel in some cases. The interest arbitration is used to resolve the disputes that can be modified in a contract and that controls the wages and terms and conditions. There is a settlement issued to the employee, union, and employers for a hearing. In the hearing, the evidence is presented by both sides and the arbitrator then makes a decision. Interest arbitration is mandatory in the public sector, but it is voluntary in the private sector. Private sectors do use it in some cases. For example, the MLB has in the past. And then fact finding is the method when a neutral third party is brought into the situation and investigates the different terms, gives recommendations on how to continue with the settlement. The hearing the fact finder performs will let both sides make their case. The fact finder will then present a report that specifies the terms of the settlement. These terms are non-binding, so they are just suggestions. Fact finding can help by giving unbiased settlement terms. It can help reduce the narcotic effect. And lastly, if it is reported publicly, the attention will push both sides to come to an agreement.
All right, and as for the case study, replacing strikers by inverse seniority, saving costs, or coercing employees. For the case, Child Care Services operates 12 care centers. A local of the American Federation of State, County, and Municipal Employees has represented the employees at CCSI for over 15 years, with the most recent collective bargaining agreement covering 80 non-professional employees. 4 teachers were covered by a separate contract. In anticipation of the June 30th expiration date, CCSI, represented by attorney Donald Burrister and executive director Susan Gruber, and AFSCME, represented by the staff rep Elaine Mendez and 5 bargaining unit members, bargained between April and June. However, the parties were unable to reach an agreement. In the final attempt to craft a settlement, the 2 parties met on June 27th. At the bargaining session, the union presented a proposal consisting of $1,500 annual wage increase, employer paid health insurance, shifts assignments, and a few other items. CCSI countered with a final offer of no wage increase and sharing of health costs. Barrister also said that if there was a strike, the child care centers would be operated by permanent replacement and strikers would be replaced by inverse seniority. In other words, employees with the most seniority would be replaced first.
Later that evening, the union held a membership meeting and the negotiating committee briefed the membership on the day's events. Many employees were upset at CCSI's plans to replace employees by inverse seniority, especially because of the negotiating committee would be the first to be replaced. The employees on the committee were 1st, 2nd, 5th, 9th, and 19th on the seniority list. By a large margin, those presented voted to reject the company's final offer and to go on strike. On July 1st, 54 employees went on strike while 26 did not. Over the next few months, 34 replacements were hired. During the strike, there was no mention of unfair labor practice allegations or the inverse seniority replacement plan. The picket sign read, "On strike for fair wages and health insurance." On July 25th, Mendez met with Barrister and told him that the strike was over and made an unconditional offer to return to work. In January, CCSI began offering reinstatement to the strikers by seniority. So these are the discussion questions. The first one states, assuming that the replacement plan violated the NLRA and was therefore an unfair labor practice, was the strike then an unfair labor practice strike? As a group, we decided yes, because there was a proven unfair labor practice. And not only that, the NLRA also stated that if an unfair labor practice has anything to do with causing a strike, then it is an unfair labor practice strike. The next 2, we're just going to leave for you all the answer on D2L. And that will wrap up our presentation. I hope you guys enjoyed it. Thanks for watching and have a good rest of your day.